Okay, good afternoon, ladies and gentlemen. So we're now in week 11. I have not been responsive in the last week since because of my personal reason. Sorry to neglect, and I'll make it whole for the 14th week through the end of this term, and perhaps you'll get it in integration for the whole of the subject, American legal system and law and public policy. In this class, we'll discuss some of global issues and public policy, and also we could have some insights about public policy with the specific example what I've touched on a USTL and International Trade Administration. Typically characteristic when we approach a national context of a public administration. So they would often act in the international trade regime. So quite in some cases interactive with international authority, and they would be also a prime engineer, for example, because of their influence in others, to share the common ideas for trade liberalization and non-discrimination, which is actually considered as level playing field for fairness of trade. What is fairness? Prevention of arbitrariness, and fairness is actually ultimate ideal the public policymakers often envisage. And what a special focus, perhaps about 2/3 of this class would be elaborated on the law of public employment. So consider the structure of the subject. It will enable us to have a holistic viewpoint when we consider the actors, stakeholders involved. And often the administrative law and public policy would be viewed in interactive profile between outsiders and agencies. So you can identify the kind of a client-like relationship to the agency. Who are those? Typically regulated, largely regulated corporations, commercial broadcasters, for example. And actually, the political address would be in scope, which is ample, and many players and entities, and typically in that context you will have some insight about the modern capitalism. So the role of agency could be created in more ambition in response with response with the development of a capitalism. So how could they ensure a social justice, and how do you promote the economy, national economy, and others? Actually a web of interest and a policy points of consideration would involve to create the rules and in the context of implementing the public policies. Then this class would be some typical if it considers some weird issue. So we now deal with the insiders within the public organ, which, however, would be very significant given many a viewpoint. We once considered the Bavarian concept of a bureaucracy. And bureaucratic sociology is now not a unusual word. We could get to be minded about many public dealings and points of consideration. So, how do we save some adequate rule about the public employment is very implicating. You consider. Then, what do you expect it to be progressed? For example, you may consider a termination hearing about a dismissal of public employees, and you may also imagine the kind of competitive exam to step the public office, which would be in comparison, not exactly in contrast, but it complements complements this poll system, and the history also is very in flavor, or what you consider, for example, the Pendleton Act in the late of 19th centuries, and also you know the Lloyd and Lafayette Act, which what actually is the pioneering work product about the important piece of legislation to orient the kind of a bureaucratic, normative bureaucracy. So determination would now be contended by way of a hearing, or what kind of opportunity to be heard. You consider the due process, procedural due process is now advanced to remedy the personnel affairs in the bureaucracy, and that historical context would what actually ignite kind of a system in the United States. Who is Lafayette, for example? He is one of eminent progressive politicians. He is born in the state of Wisconsin and studied law in the law school, and he is one of important figure about equal suffrage. Was mentioned about fair opportunity to participate in national politics, and so the kind of a reform and a progress, social progress, was well charted across the turn of the last century. And the Pendleton Act also be understood in the context. And later, that initiative was very systemized by a follow-up works, enactment, Civil Service Reform Act of 1983, for example, an Equal Pay Act to ensure same pay for the identical jobs. It may expand, for example, the kind of concept comparable works. So now the quest for equal pay among different races, typically sexes and ethnic minorities or others would be expanded. For example, who are the nurses from University of Washington? It is a public university, as you know, and the context could be investigated in our framework. You consider subtleties and basically in the sort of a structure. You consider you need to make it distinct between private and public employment. So the theory might be expanded into private terms, but basically we now stay in the public context of employment. Some loose form would be dealt in terms of a government contractual program, for example. So, for example, the city of Richmond versus Coles, you will have some court elaboration about affirmative action. The non-minority private contractors are not obligated to set quotas, racial quotas for their subsidiary contractors. So the affirmative action is an important public agenda in the United States, and the court would often consider the compulsory quotas would not be sustained. It is often declared unconstitutional. However, as you consider in Becker case, the public university may be allowed to consider the racial factors in the admission decision process. However, the quotas could not survive. It should be struck down. And so the role of court over the course of issues and points of contention is still important, which is same with other subjects we discussed over this term. So the court holding and the rules developed by a judicial authority often is important to substantiate the void of a legislative initiative. So you may recall on the same structure and context. I have said the judicial authority is important in terms of oversight and the kind of a rule of law ideas we expect in the public relationships. The issue dealt in this class is a little esoteric, since it actually triggers the internal affairs, personal affairs. Nonetheless, the court law is very extensive, you consider, since the legislative products are not very extensive practically. So what is the exact meaning in this specific context? So the court often is now advanced to render it invalid on its face. Often the court stated that the specific measure should be deemed unconstitutional as applied. So the court authority is fairly determinative for the individual and what actually specific grievances raised in the context of public employment. So I have illustrated some of what landmark cases in this area of concern, and one other statute, which is milestone in the wake of a reform, Civil Rights Act, which is actually an important piece of legislation to promote the insular classes of society in the United States, and so actually coupled to support the Bill of Rights enshrined in the Constitution. And that statute also is influential in shaping the understanding of this concern. And in the course of discussion, we'll consider other points of in terms of protections for public employees. Often it is substantive against the procedural aspect of concern. So you now well be versed of the Matthews Doctrine about due processable concept. And the concept is foundational through the controversies involving public employment. So actually the court considered three distinct factors. What is the harm to be incurred by the parties of grievances? So the extent of harm is one factor, and the court may say it unacceptable if the harm is so great without a due afford of a constitutional procedure to be heard, opportunity to be heard, to raise dissent, and present a supportive evidences in favor of his case. And what are others? So the government interest is actually counter-casus. So the gravity of government interest about a provision of a process is also considered, and the kind of a point was discussed last week as was gets through, and the content of rights, for example, right to counsel and adversary proceeding would be most advanced form to be afforded. So please, once again, please recall the dealings delivered in the last class about Matthews Doctrine. The context we now think about is about substantive rights provided by a Bill of Rights, notably freedom of political expression would get into our share. So assume if the teachers of public colleges, public universities may make a critical statement in the point of a was what a then is it legitimate to dismiss without guaranteeing any due procedure about its what often, for example, consider the Ross case. He is one example. He served in the public university, University of Wisconsin, Oshkosh, and he actually worked on the basis of contract, a one-year term. So his expectation would be slim to be rehired. Actually, no concept of property right could be bred in that context. The university decided not to rehire a one-year contract professor, and without no reason being given to that aggrieved party. And the court approached the issue from the purview of a proper concept. What you will know some important research work titled "The New Property." It was published by Charles Wright, Yale Law professor in 1964, and a very influential work about this area of concern. So, as I've said, the concept would be between entitlements and privilege. But often in that attribute of a relationship, we may only find the context of privilege. It's just an expectation that could be obtained in compliance with the contractual terms and others. So they have no strong voice to force their interest as a property right, so could not safely argue that he should be entitled to due process to be heard. And also the context of dismissal is very subtle, given his chance to be rehired in another public university. So the court may have some implied concession about the need to not to announce publicly the reason to dismiss the employee. So it actually entails some subtle point to affect the interest of both parties. So the court may sustain the position of university about its non-mentioning of reason of dismissal, and no kind of a fine administration in that sense. If consider, however, the university would give some stated reason and may be available to the public notice, then the court might see it adequate to provide some hearings or any chances to protest they procedurally dismissal. And the protections could made slim, for example, about some anti-employer criticism, the kind of defamation about Board of Regents for the colleges, which would be public, of course. So the case of Sinderman could be coupled which would illuminate the difficulties about a proper ruling. He is a faculty member at Odessa Texas Junior College and previously employed at 6 other Texas junior colleges. And for 3 years at Odessa, pursuant to a series of one-year contracts. When he came into conflict with the College Board of Regents for advocating the school will become a 4-year college. So this, a school reform as one of strategy, what is a personal belief, might be a personal belief for a decent education. He actively criticized the residents, and advertisement critical of the residents appeared in the newspaper of his name. Further, because he was the elected president of Texas Junior College Teachers Association, he sometimes missed classes in order to testify before the state legislature. So a very active figure to make a social cause and reform. At the end of his 4th junior year, the Regents voted not to offer him another one-year contract. The Regents commented on Sinderman's alleged insubordination in a press release, but provided neither an official statement of the reason for the renewal of the contract, nor the opportunity of hearing where Sinderman could try to revert any charges. Sinderman brought suit alleging violations of his 4th Amendment right to free speech and his 14th Amendment right to due process in the form of a hearing. The district court granted summary judgment against Sinderman, but the appellate court reversed. And eventually, the Supreme Court affirmed the lower court decision. The substantive element, also one other factor you need to consider in combination with the procedural requirement. We now are given a due process of law by the Constitution. And also, what are others? Right of privacy should arise in the context of public employment. And this concept is quite powerful, you consider, to extend the original ambit of a Bill of Rights. So I have once mentioned in the constitutional class, you see the penumbra of constitutional rights. So what actually the Bill of Rights is expressly ordained, but in a narrow scope about a provision and languages. And the catch-all clause is available as you consider. So the right of privacy is fairly extended about human dignity, and many new generations of human rights. In comparison, you'll consider radical evolution about generations of human rights, a 4th generation human right. second-generation human rights on the basis of a continental states in Europe, so the German constitution, and now be incorporated into the UN framework about the human rights. So actually, you may consider the concept of human rights is evolutionary, and actually adapting with the changing circumstances. How do you catch them beyond the express mandate of a constitutional provision? The concept right of privacy would be most influential. And actually, the right is the coined by one influential legal scholar you consider, and the article was now one of most cited ones in legal circle, and very impacting through the practice of a Supreme Court of the United States. And the same nomenclature in dealing human rights were incorporated in initiation of Korean constitutional scholars, but in the last reform, what is the 1987 Constitution of Republic of Korea, as one provision in express terms. Nonetheless, in the United context, the scope would rather potential to be expanded, since it has no bearing with the express provisions, but theoretically foundational to create any new concept of human rights. And the right of privacy was one eminent example would involve the right of abortion, which is quite practical about the shaping of female life cycles. You consider so female interest is very dependent on this concept. For example, right to abortion, and how to shape their and also what is that? The personal appearance is also discussed in this ambit, right of privacy. And the important precedent perhaps would be a Roe versus Wade, you consider. And the court delivered very ordinary rule about right to abortion. So it is foundational, and also the later development would involve the case titled Webster and this. And the court position is not well settled, however, unfortunately. So in that case, the court saw it very limited about right to abortion. So the mother no longer seek any extended protection about free abortion in the public hospital. So the issue would be viewed in terms that the life of fetus is how much extended about the privacy interest of his biological mother. So consider the case. Initially, the right of privacy was discussed in Griswold versus Connecticut. The Supreme Court in 1965 suggested Constitution protects a penumbra of rights implied by but not stated in the Bill of Rights itself. One of these has loosely been called the right of privacy. And when the government places conditions of public employment, the conflict with an individual privacy rights, the courts apply a balancing test. As the dissenting opinion in Kelly versus Johnson makes clear, the members of current court disagree not only with the outcome of a majority's weighing process, but with the very idea the fundamental rights, such as privacy, should be balanced against a governmental interest. So the balancing test is one of a common way of approach about a constitutional controversy. You will see some weightier process, elevated concept of about a strict scrutiny or intermediate scrutiny. So the structure is very notable. What about the gender equality in terms of this frame? So intermediary scrutiny would be adequate. But against some other worse context of discrimination, race or minorities. And in other cases, the balancing test would be prevalent, which requires some lesser standard about the constitutional compliance. You consider So, what is the concept compelling state interest? It is the word often used in the strict scrutiny. And what is the word others? The controversy over privacy as constitutional right is grounded in very different interpretations about what rights are protected by Constitution. What are legitimate state interest, and also how do we balance between the harms and the government interest? The code would not be seen on inconsistency about a time element, because in some terms, conservative ethos would be more stronger, and in other cases we see it as contrary. While the court in Roe versus Wade, this is 1975, formed the interpretation of privacy in Griswold versus Connecticut, a new conservative majority in the court has indicated the right may no longer be fundamental, at least for women who seek abortions from public hospitals. So it is exactly the holding confirmed in the case Webster versus Reproductive Health Service, says in 1989. So the right to privacy is under attack not only in the area of abortion, but in other areas directly affecting the rights of a public employment. One of a frequent issue raised in the context of public employment actually includes the mandatory drug testing. The drug policies of Reagan and Bush administrations specifically target public employees. Then, the question is, should the right of privacy prevent the government from implementing mandatory drug screening program for public employees? So, assume if you are a job applicant for a library page for a public library. So, the public library so it comes into our frame, consider. Then, is it permissible so actually it involves very difficult issue. In the case titled Lane v. City of Auburn, decided in 2008. Reveal the context of a contention. And also, you will now be illustrated with one other recent controversy about sexual orientation of public employees. The controversy was raised from the Air Force in the United States. Don't ask, don't tell policy. What is that? Yeah? So, you may see it adequate that the government has a right to know one's sexual orientation and whether such information constitutes grounds for discharge. So, how much the right of privacy could be ensured? It is actually now contended. I suppose if it would not be appealed to the Supreme Court, the final ruling could be identified in Ninth Circuit in a 2-1 ruling. The court agreed to the extent it found applicable the strict scrutiny test of law's constitutionality, rather than the less stringent rational relationship test, and remanded the case back to the district court to determine the degree of governmental interest advanced by the law. So what does it mean? Often the strict scrutiny means the case would be condemned on the constitutional ground. So it actually falls within the kind of a personhood, province of personhood, but there would be some need about a public need to intrude the privacy of person in permissible ways. Nonetheless, it still could be indecent in the prevailing sensibility of U.S. citizen that could it deserve a confidential. And you also need to know the Title 7 of Civil Rights Act of 1964. It prohibits discrimination on the basis of color, race, religion, sex, national origin in employment decisions. The Act affects both hiring and firing decisions. The statute itself states no concrete definition of discrimination, although it does expressly prohibit discriminating against employees or job applicants who have protested or otherwise tried to correct alleged discrimination. So, as I've stated, the code plays an pivotal role to dispose of specific cases, and which actually could complement the void or insufficiency of a statutory specificities. The court set upon the main task of formulating the specific meaning of discrimination and shaping the evidence that those alleging discrimination must prove to sustain the case. And in understanding of the statutory frames of this act, you may consider three distinct factors: evil motive and what are others? Discrete impact and differential treatment. The kind of concept is actually essential to create specific rules in concrete basis of a controversy. And according to the title, the aggrieved party must show prima facie that he or she belongs to a racial minority, that he applied and was qualified for a job the employer was trying to fill, that he was rejected, and that thereafter the employer continued to seek applicants with the plaintiff's qualification. One of important case concerning this Title 7 is a McDonnell Douglas Corp versus Green. Green involved a private corporation, but the same rules of proof apply in nearly all respects to public employers. However, as the next case, Washington versus Davis, decided subsequently in 1976, indicate the standards for proving discrimination are not always the same for the public and private sector. So perhaps a different standard would be due and adequate because of many reasons, as you expect. And often the public employer may well be seen to dismiss the employee without stating no specific reason or any the kind of a virtual concept. The at-will doctrine is notable in the employment relationships in terms of law and jurisprudence, you consider, and that is foundational, as you see, since it arises from basically the contractual understanding, what meeting of minds, the employment contract. So at-will doctrine is actually prevailing through the labor laws, and you consider many reforms in the states of European continent, and EU has many advanced form of public dealings to revamp the harshness of at-will doctrine. And the beginning point would perhaps differ in that point of consideration. The context may be delicate when we enter into the public employment. And the court would see it indispensable to ensure loyalty and faith from public employees in some cases. However, so may permit some harsh measures, but that would not be consistent through all the differences between private and public. In some cases, private forms of employment would be less protected. So the extent is made different on a case-by-case basis. For example, consider one prosecutor who was transferred to some undesirable position because based on the finding that the superior will see actually unpleasant to hear the kind of criticism about it. So consider the structure in this frame. Private, conduct was speech acts as a private citizen, and it might be a purely a private, which should be emancipated from any constitutional obligation. In other cases, you may encounter the speech act or conduct as a private citizen, but that content of statement of any expression would be the kind of a public concerns. Then how do you differentiate between two situations? And assume further if the officers would act in as capacity as officer. So the context is official, and also the content of speech or other behavior could be public or private. So four blocks could be well formed to make it plain. Of course, it depends on subtleties of case involved. So in that case, the prosecutor made a statement or opinion about worse preparation filed by a police officer. So his criticism might be intense to provoke anger of a superior or some. Then he was ordered to be transferred to other position, and he denied is a job command. Then he was dismissed. Then consider is it permissible to the code would not say it revocable, the decision of dismissal revocable, since the controversy is controversy as a reason in the official capacity of a conduct. How do you see it plausible? And what is substantive nature of expression? Of course, it is a public concern, since he argued on acceptability of a official document, which is what actually as related with his official duty. I have accepted one picture. Kyoso is popular in South Korea. He's now serves as an incumbent congressman, later elected I'm sure he was made into that office as a matter of law. Might be in order of succession about the vacancy of his successor. In any case, he is now a congressman, and he is controversial about course of his official service, a long pledge to on the role of as a critic about a Supreme Court policy, and do you consider if he is a whistleblower? I'm not sure if he's a whistleblower. The United States has the act to protect the interest of whistleblowers. The whistleblowers often considered as most of evils in terms of organizational or purpose. So he might be condemned seriously from his colleagues and heads of organization others. Nonetheless, it would be a good source of a public advancement. So information needed to assure a social justice could stem from the work of whistleblowers. He made a influential speech to change the society or organization for it. So the statute was arranged to protect the whistleblowers in due context. Of course, there is competing interest about the context of issue, development, and others, and many. So the prank card was read at Judge announced the resignation, and the people of his support gathered to congratulate his resignation. In any case, he was but to be resigned from many pressures and others, and he failed to obtain a renewal by the Supreme Court authority. So compare two cases about the public prosecutor in the state of California in the United States and the judge of the Republic of Korea. Perhaps the standard would be more stringent about protection of public employees. In South Korea, so Seok-Yo is actually a long, good worker in light of a critical law against the prevailing policy of judiciary. But he was let to practice carry his official duty. It was for no disadvantage about transfer orders. So, but eventually he was dismissed since he comparable and reminiscent. And who is this figure? It depicts this 20th President of the United States, was named Garfield. He served a very short period of presidential terms, 200 days. He was the second of four presidents in the United States history who was assassinated. Assassin is a mad office seeker, and I have mentioned the Pendleton Act and the stage of a the turn of a last century in the United States, and many public system and institutions will evolve around times. Typically, we know the support system in the United States is actually very strong and persistent. Nonetheless, a piece of a reform has been witnessed in this period of time. So Pendleton Act, Lloyd Lafayette Act of 1913. The President Garfield was classman and lawyer. Later studied law and become a lawyer, and entered into Ohio Bar as a member and elected. And his initial drive was to remedy the support system, perhaps. So he likes to elect public officers based on competitive exam. So, Kosi in Oriental practice, long persist of history. Now we have some modified form of institution. You can see that. So President Garfield made an effort, to disrupt the Conkle crowd. Who is Conkle? Senator Roscoe Conkle is based on New York State, and he's leading spoilers of day. And one other figure, Chester A. Arthur, who stalwartly supported his position. Arthur became vice president under James Garfield in 1881. Garfield soon offended the Conkle crowd by refusing to make any of the spoils appointments, but they recommended. 4 months after the election of a frustrated and presumably mad office seeker associated with the Conkle crowd, fatally shot President Garfield. On assuming the presidency, Arthur, sincerely shocked by the assassination, turned against the support system, and with much general public support, promoted adoption of the Pendleton Act. However, this is fairly a small plan. In that act, only 14,000 employees were initially covered by the act. However, through an interesting political dynamic, politicians steadily expanded its scope. This occurred because the act permitted the presidency by executive order to expand its coverage. So, executive order is now a great avenue through the presidential policy, as we consider, for example, what is LPO, representative political appointees, and many important systems significant to address the administrative needs in the United States was rendered in the form of an executive order. As new president took office, they deliberately expanded the act to cover their own political appointees so as to freeze them in their jobs after the president's term ended. The Pendleton Act itself provides few modern legal protections. And Justice William Rehnquist in Arnett versus Kennedy noted the very limited nature of its protections. So, actually, truly it is limited, since the Act merely deals with the recruitment of public officers. As I've said, for example, competitive examinations and the concept of a classified service, for example, would be introduced in later development of legislation. And also promotion, a remuneration of public employees, and more importantly, the termination of a public employment would not be dealt in this Act. So all other elements except the recruitment would be forgone and waived. No chapters in this Act. Sorry. Okay. Time is up, and there will be all for this fourth session, and we'll see soon in the second session of this class. Thank you for your attention.